A very good evening to everyone. Those of you who were able to attend the scheduled Zoom class yesterday, thank you for making time. At least it enabled us to dispose of some of the outstanding presentation from the task that we give you with respect to confidentiality. So well, I noticed that some of you are still having difficulty in being able to mute yourself when you are not required to be talking. So I'm going to mute all of you. On the other hand, should it become necessary for you to talk, I will be happy to see you raise your hand so that you are unmuted. That way, we are able to control background noise, which can disrupt the sound quality. So I'm muting everyone now. Let me see. So mute. Oh, okay. So you're all muted. Good. Okay. So last week we started the very introduction to medical malpractice, and for that matter, clinical negligence or medical negligence. And what we sought to do was to practically come to terms with the very sensitive position which healthcare professionals actually occupy with respect to our our treatment. And especially so, you look at how if something goes wrong, as far as patient treatment is concerned, there may not be a second chance for the patient. And that may be the death of that patient, or if not even the death, the quality of life of that patient may significantly be distorted for the rest of his or her life. And that actually raises the stakes when it comes to treatments. And for that matter, it should also inform us how the law should be positioned to deal with errors or mistakes, mishaps, accidents, and of course, in some cases, I don't want to say intentional harm. Of course, human beings can also be wicked, because we have the cases of Dr. Shipman, Harold Shipman, if you remember, the UK doctor who is said to have killed over 100 of his patients in a very systematic, gradual fashion. And of course, Ghana too. We can also get maybe our own examples of doctors who may be very callous, very heartless, and may just want to exploit the vulnerability of patients by deliberately inflicting harm and even causing death, which need not happen to some patients. So that is the reality. And this is a very important backdrop or background, which we would like all of us to bring to the fore of our mind as we embark upon a more nuanced discussion of medical malpractice, for that matter, clinical negligence or medical negligence. Then we also made, those of you who've been to the class platform, I've pushed stuff to you. Well, I will endeavor to go to the virtual class and put some of these materials there. And I hope that the difficulty which we had last semester, probably where some of you could not go to the KNUSC virtual class to access materials has been addressed. And again, I talked to some of the very senior management, including the Pro Vice Chancellor, regarding quality of internet connectivity on campus. And my check indicates that about a week or so ago, they have brought in another company, which have actually improved the quality of connectivity on campus. So I think that that should enhance the quality of our engagement should you decide to do Zoom as we are presently doing. Yeah, so having said that, I would like to urge you to read and brief all the cases which are on the case list. And I said, read and brief. Well, and I'm happy to say that having finished grading of your papers, I think there's good news that a good number of you did very well in the first semester exams in the medical law. And I hope that you will let it motivate you to even give your best so that second semester will also be very impressive and even far better. Of course, I appreciate the fact that you didn't have much to read last semester. So that is very much appreciated. Nevertheless, this semester, as you know, we have a lot of things and that you have to start serious learning. Don't say that you're waiting till exam. Well, maybe we will plan with one or two classmates, class reps and see if you can have some small get together to congratulate you for your good performance last semester. So we would like to move on to discuss the elements of clinical or medical negligence in detail. Last week, I reminded you, and I'll say reminded because you've learned law of thought, and in law of thought, you spend a lot of time on negligence. And we know that before you can have a claim in medical negligence, and for that matter, any area of negligence, we need to establish the existence of duty of care, that there has been a breach of that duty of care, and as a result of that breach of the duty of care, maybe injury has been suffered. And so all these three elements will have to be established, and it's not different in the area of medical negligence, except that, as we indicated, when it comes to probably the establishing the breach of the duty of care, that is where some debates may actually be encountered in the law and also the jurisprudence as to whether we should have a very special treatment, a very unique approach to this area, or we shouldn't vary the approach and it should be the same as in the general area of negligence. Now, tonight, we would like to concentrate first on establishing existence of the duty of care and also look at the breach of the duty of care. Of course, we know very well that since 1932, in the very seminal case of Donoghue and Stevenson, which is actually a landmark in the sense that it actually changed how we understand negligence. And we remember the very famous wisdom of Lord Atkin, who held that a person owes a duty of care to another, where injury to that person is reasonably foreseeable. And you ask, what is reasonably foreseeable? And we remember very well the words of Lord Atkin in trying to explain, that one must take care not to injure one's neighbor. And then he asked a question. Someone who asked, who is my neighbor? And you say that, well, to the lawyer, your neighbor Of course, not like how the Good Samaritan was explained, but your neighbor is one who is so closely and directly affected by my act that I ought reasonably to have them in contemplation, has been so affected by my act that I ought reasonably to have them in contemplation. So we are talking about the proximity, the closeness of our relationship with whoever is supposed to be affected by our action or omission. Now, in the context of doctor-patient relationship, establishing existence of duty of care is not something which is difficult at all. Since any patient is closely and directly affected by their doctor's acts, we can confidently say that a doctor ought reasonably to have his patient within his contemplation, and any injury caused by a doctor will be reasonably foreseeable. Of course, we do not need to dispute the fact that if a doctor is carrying out his work as a doctor, a healthcare professional is carrying out his work as a healthcare professional, he needs to exercise requisite care, because if he does not do that, somebody is going to be affected. And who is that person? Definitely the patient is going to be affected. So we don't really have a lot of, if you like, difficulty trying to determine if the doctor or the healthcare professional owes the patient duty of care. So if you go to the hospital, the doctors, the nurses, the paramedics, phlebotomists, and all those who are playing one role or the other in relation to diagnosis and treatment of the patient, they owe the patient a duty of care. They owe the patient a duty of care. Of course, we are also cognizant of the Caparo test. Remember the famous case from Caparo and Dickman, which also provide guidance in terms of establishing existence of duty of care in novel situation. So in new situations, can we say that a duty of care arises between the claimant and the defendant? So the principles which we saw from Caro and Dickman, and at this stage, I am assuming that all of us have passed our law of thought, otherwise we wouldn't be in the level 300. So that is, so I'm just building upon that knowledge, and I will excuse myself from being detained by some elementary things which we have learned or ought to have learned from our law of thought class. And there are plethora of cases in which we can see duty of care relationship between patients and the doctor. You can see a number of cases. If we look at the cases like Pippin and Shepherd, a very old case, even as far back as the 1822. I'm not sure even those who are very old among you, Martin, Alele, or anybody was born. Yeah, so, but as far back as 1822, the courts, the courts were able to say that a doctor owes the patient, if you like, a duty of care. And not only that, if you also take the R.M. Bateman, a criminal case, and Chief Justice Lord Hewitt was prepared to note, and I quote, that if a doctor holds himself out as possessing special skill and knowledge, and is consulted as possessing such skill and knowledge by or on behalf of the patient, he owes a duty to the patient to use caution in undertaking the treatment, unquote. In other words, in the wisdom of Chief Justice Lord Hewitt, insofar as you have accepted someone to be your patient, in the sense that you have made that person believe that you have the requisite skill or competence to attend to him or her, then a duty of care is created for you to ensure that you do not cause injury to that person. Now, fundamental question in medical or clinical negligence is, who can a patient sue? If you've been a victim of medical malpractice or negligence and you want to sue, who are you going to sue? First and foremost, your first defendant will be the medical professional or the healthcare professional who treated the patient or who treated you as a patient. So he may be sued directly. However, because the healthcare professional may not have enough resources to be able to satisfy any judgment, debt, or compensation which may be awarded in your favor, should you be successful in the litigation, it will be wise for you to apply the doctrine of vicarious liability so that you don't sue just the healthcare professional, but you sue the employer of that healthcare professional. So certainly the employer is working in a hospital or healthcare facility, you will sue the employer as well, a particular hospital. And well, in the context of healthcare insurance scheme, you may also want to sue the provider of the medical services. So maybe like the insurance company, they have nominated certain facilities as the places where you can access the care that they are prepared to pay for and all that. You can also sue them as it were. So maybe let's say a few words. Yes, the medical doctor, if you wanted to sue him, as I said, it is very straightforward, just like any ordinary tort, because the person whose act or mission has caused you the injury, he is the target of the litigation. Maybe when it comes to health insurance again, well, in the UK, for example, what happens is that we have like the National Health Service, which is our equivalent of the National Health Insurance Scheme in Ghana, or the National Health Insurance Authority. So, like almost all the hospitals, the primary and the secondary and tertiary care, they are funded by the insurance scheme called the NHS. Now in Ghana, we have equivalent version, but not exactly. So what happens here, as we know, is that certain hospitals have been given accreditation, meaning that if you go there and you incur debts in terms of cost of care and all that, the insurance authority, the National Health Insurance Authority, will pay for that. But if something should go wrong, can you sue the National Health Insurance Authority? Can you sue the National Health Insurance Authority? Maybe let me take some view. So I want one lady and one gentleman to contribute. Or Martin, you want to, I know you've muted yourself, you want to speak? Okay, let's hear you.
Okay, yes, Doc. Doc, I don't think that you can sue the National Health Insurance Authority in this case, because the Health Insurance Authority is there to take care of your health, but not the negligence of the doctor, because when it comes to vicarious liability, it goes to the employer, but not the National Health Insurance Authority. So that's why I think that you cannot sue the National Health Insurance Authority in addition.
Oh, okay. But let's look at this. Okay, let's take the lady before I come in. Yes, another, but this time a lady. Yes, raise up your hand and then I'll mute you. Which lady wants to speak? Which lady wants to speak? Okay, so Elsie, edit. Yes, you can go ahead.
Yes, I think I agree with Martin, because in this case the doctor is not employed by NHIS, so maybe if we want to attach his employer, it would have to go to the Ghana Health Service and not the National Health Service.
Okay, but let's look at it this way. Let's suppose that you went to a hospital which is accredited by National Health Insurance Authority, and they said that you were told by the management of the hospital that, well, for this particular condition that you have brought, the National Health Insurance Authority is not paying for it, and for that matter, we cannot treat you unless you are prepared to pay. So let's suppose that you do not have the means to pay and you develop serious complication or you even die. Can the Health Insurance Authority be sued? Yes, any thoughts?
Doc, I think no again, because the insurance that you have gone into is a contract, and mostly they only publish the drugs that that are in the health insurance list. It's not every drug that is there, and so you are aware of it and you have gone into it. So if you have gone into it and you are being told that this one is not covered with the health insurance, I think they don't owe you any obligation, Doc.
Okay. Yes, any lady? Now, okay, Elsie, go ahead. But I noticed the class has appointed Martin as your Speaker of Parliament and Casey too as your speaker. All right, so go ahead.
Yes, but once again, I agree with Martin, because the National Health Insurance Authority has, I mean, it's easy to find out the kind of services they cover. For instance, I think they don't cover dentistry also. So if you have to see the dentist, you have to cater for the cost of that yourself, and some other illnesses or ailments, as well as some drugs. And those exclusions are actually easy to access. You can find out which services are excluded by yourself. So I don't think they can be held responsible for refusing to provide funding for things which they have expressly excluded in the services.
Yeah, but Elsie, when we are speaking, we like you to speak up. It's like your voice has not come out clearly.
Yes.
Okay. All right.
Can you hear me?
Yes, I can hear you. Yes.
So I was saying that I agree with Martin because the National Health Insurance Authority has expressly excluded some services and even some drugs, and I don't think they should be held liable for things they have expressly excluded from their services, for failing to fund illnesses or drugs that they have expressly excluded from their services.
Okay. All right. Yeah, I mean, this is a very difficult area, but let's look at what happened in the case of Bull against Devon Area Health Authority in UK. Of course, the health financing, the insurance system over there is somewhat different from the scheme we have here. But we may derive some assistance in terms of thinking around this type of problem here in our jurisdiction. Over there, the relevant health insurance authority, the health authority was held liable for breach of its primary duty towards its patient. What happened? The plaintiff was in labor, giving birth to 2 twins. After the first twin was born, the junior doctor called for urgent assistance from a more senior colleague, very similar to the story I told you last week. Due to the hospital's design or how the arrangements, the working system is organized in that particular hospital, the other doctor was on another site, which was over a mile away from where he was called. I mean, very similar to what happened in one hospital in Ashanti region, which I told you about, I will not mention the hospital. The other doctor was on another site, which was over a mile away from where he was called. And it took him over an hour to attend the call. So the second twin was subsequently born with severe brain damage as a result of the delay. Those of you who know delivery, when the head of the baby is getting out of the vagina, it doesn't have to remain in the vagina for a long, for a long period. It has to come out, there's a time. And if it delays there before getting out, that is where you get this Down syndrome and so on. So if you see some children, you say that this child has got a Down syndrome, it's like the brain is not functioning properly. They are all, if you like, a labor complication related. Now, the health authority, when sued, argued that since the hospital was situated on 2 sites, there would inevitably sometimes be a delay in attending to a call. But the health authority was still held liable because they failed to provide an efficient system of care. So it's just like, let's say you go to, let's say, Nkrumah, for example, and this same thing can happen there, that maybe one doctor who is not like a consultant is handling a case, and the more senior one is also on call. But let's say that he is at the, let's say, the polyclinic, and you are the case is being handled at the Kofor emergency. Those of you who know the geography of Nkrumah teaching hospital. And let's suppose that the procedure happening at the Kofor emergency is such that if whatever needs to be done is not done in 30 minutes, it will actually lead to more serious complication. And let's suppose that the more senior doctor from the other side delays in getting to where he was needed, and something happens, then question may arise as whether the hospital can be held liable for breach of its duty of care. Well, in doing that, the court will need to analyze whether, having regard to the physical arrangement vis-a-vis the operational strategy, which the hospital was operating or using, such as maybe letting the more senior doctor be at the polyclinic and all that, and then he could be called on call and all that, and looking at the time for moving in between. All those things may be useful factors in helping the court make a determination as whether we can say that in the circumstances, the particular hospital failed to live up to its duty of care as it were. And it is very instructive to look at the dicta of two of the law justices who sat over that case. Lord Justice Slade, for example, had this to say, quote, "The duty of a hospital is to provide a woman admitted in labor with a reasonable standard of skilled obstetric and pediatric care in order to ensure, as far as reasonably practicable, the safe delivery of the baby and the health of the mother." And Lord Justice DeLeon also remarked, quote, "In my judgment, the plaintiff has succeeded in proving by the ordinary civil standards of proof that the failure to provide for Mrs. Bull the prompt attendance she needed was attributable to the negligence of the defendants in implementing an unreliable and essentially unsatisfactory system for calling the registrar." So at least this particular case gives us a sense of how a court may reason when it needs to make a determination as whether a particular hospital or health facility, by the way that it is designed in terms of its operational system, whether it could be blamed for not exercising the requisite duty of care or not. And a number of cases have come up. We can recite a number of them. So let's look at the case of Garcia against St. Mary's NHS Trust. You see, we may be wondering, why is it that we don't have too many Ghanaian cases? And sadly, we live in a jurisdiction where medical malpractices are happening every now and again. And a lot of people are even dying in circumstances in which we can say that maybe it's not time God wants them to die, but just because of somebody's negligence. And yet, these cases are not taken up in court. And that explains why, despite the obvious increasing number of cases, we don't have reported or decided cases on the subjects. Just a handful, Asante, Kremo, Jan, and so on, but there are not many. So what happened in the Garcia against St. Mary's NHS Trust, decided in 2006. In the Garcia's case, the claimant underwent coronary artery bypass surgery. The operation appeared to be a success until the plaintiff's condition rapidly deteriorated. The surgeon on call was called at home and arrived at the hospital some 27 minutes later. The bleeding was stopped a further 15 minutes later, and the plaintiff alleged negligence in the treatment, which was unsuccessful, but the court made the finding that the hospital had not been negligent in the delay in attending the patient. Because in the court's view, even if there had been a specialist on site, it was the delay that the patient experienced which was not unreasonable. So the delay was not an unreasonable delay, which could actually measure up to the threshold of letting a duty of care to have been breached by the hospital as it were. But in terms of whether a facility or unit provider can be sued directly, we may want to look at this interesting case of HIV. The case is titled Ray HIV Hemophilic Litigation. And in that case, we get an example of how the Secretary of State of UK, well, maybe like a equivalent of, if you like, the Minister of Health or the Health Ghana Health Service, if you like, if in the context of Ghana, was sued in that case in the UK by patients who sustained damage after being transfused with blood products which were contaminated with HIV, following a failure to adequately treat these products and the failure to warn the patient of any potential risk. So people are being transfused with blood, not knowing that the blood that were being transfused was already contaminated with HIV. And I mean, even these matters I'm talking about, they are happening all around us in Ghana, but again, nobody takes them up. And that is why we don't get to read about them. Now, does a doctor owe a stranger duty of care? In other words, you remember the rescue principle in tort, and then the famous words of Justice Cardozo. Remember the words of Justice Cardozo as far as rescue principle is concerned? Can anybody remind us? Can anybody remember us of the beautiful words of Justice Cardozo? Anybody? You're not making the case, the class interesting because you don't talk. Only Martin and his friend Elsie have been contributing. I have to call names, so okay, whose hand is up? Whose hand is up? Let me see. Okay. Yes, Ajato Israel. Yes, Ajato Israel, please. Go ahead.
Okay, Doc. I don't remember those words exactly, but maybe I could summarize it in my own understanding.
Yes.
Okay, so he said something to the effect that as a rescuer, if you do something beyond the normal aid you provide to the victim, you can be held liable if something happens to the victim.
Okay. All right, good. Yeah, so thank you, Mr. Ajato. Good. No, Justice Cardozo, I'm sure if you haven't read anything about him at all, you ought to have read this book called The Judicial Process. And if you're in the third year, you've still not read The Judicial Process, please see me in chambers so that I can guide you to get it and read it. Because it's very embarrassing and shameful if you've learned law up to this stage and you haven't read The Judicial Process. Okay, but Mr. Cardozo made the beautiful dicta. Danger invites rescue. The cry of distress is the summon to relief. The emergency begets the man. The wrongdoer may not have foreseen the coming of a deliverer. He is accountable as if he had. Yeah, so those are the words of Justice Cardozo on the rescue principle, trying to set the parameters within which a volunteer or a person who is on a frolic of his own, as it were, could incur liability. So therefore, what duty does a doctor owe to a person who has collapsed in the street, or maybe where a person on an airplane may need urgent medical attention? For example, you're on the plane, there's a pregnant woman, and then the cabin crew make an announcement. Please, do you have any doctor among us? Meaning that the pregnant woman is in labor, or there's an issue and they need the doctors to help. So if you volunteer, do you still owe a duty of care? So that is the crux of the matter we are probing now. Well, as we know very well, the common law does not impose a duty upon a person to act as a good Samaritan. So the Good Samaritan principle in the Gospel of Luke, I'll not ask for the chapter. I know some of you cannot even tell me the chapter, but at least we know it's in the Gospel of Luke, does not really apply in the common law to impose a duty just like that. So therefore, a doctor is not required to respond to a call for help. If someone has collapsed, maybe by virtue of the Hippocratic oath which you have taken, so which we saw, and also in the Beecham and Chadra's principle, the beneficence principle, that you have to do good, and the non-maleficence, you have to avoid what? Harm. So doing good means that if probably there's a situation in which there's a need for urgent medical intervention, your ethical responsibility may require that you respond to the situation. But if you put ethics aside and we take law, strictly speaking, you have no obligation to respond to the situation. But if you should follow your ethical responsibility and respond to the situation, then you incur a legal responsibility. And that was why Lord Justice Stuart Smith, in the old case of capital encounters against Hans, City Council will make the point that, quote, if a doctor chooses to intervene and volunteers his assistance, his only duty as a matter of law is not to make the victim's condition worse, unquote. In other words, if someone is in an emergency, medical emergency, is not your patient, legally speaking, you have no obligation towards the person. But probably, as a responsible ethical doctor, you may want to be persuaded by your calling as a doctor and your Hippocratic oaths and respond to the situation. Should you do that, then you are fixed with a legal obligation. And that legal obligation is that don't make the victim's condition worse than you find him. So if you go and you're going to let the condition get worse, then you're in trouble. So then don't go at all. Don't go at all. And that was why in the case of F against West Berkshire Health Authority, decided in 1989, Lord Gough made the observation, quote, the doctor in the house who volunteers to assist a lady in the audience who, overcome by the drama or by the heat in the theater, has fainted away, is impelled to act by no greater duty than that imposed by his own Hippocratic oath, unquote. So you see how Lord Gough is also even making reference to the Hippocratic Oath. And of course, the relevant tenet of the Hippocratic Oath will be that you have to live up to beneficence. You have to do good and then avoid harm, as the case may be. Yeah, so I think that is what we should keep in mind. So what is the nature of the relationship between the hospital professional and the patient? So when you talk about the hospital professional here, not only the doctor, it includes all those who are connected with the procedures in the hospital, the nurses, the various allied health professionals, as it were. Well, if you look at the very old case, which I'm sure all of you encountered it when you were learning your law of tort, the case of Barnett against the Chelsea and Kensington Management Committee, where a principle was established that a duty of care can arise when a patient presents herself at the accident and emergency department, even though the patient may not see a doctor. In other words, the Barnett case was saying that insofar as you have set up a facility as a health facility or a hospital, and then you have accident and emergency units, or maybe now maybe like the casualty unit or whatever, then the assumption is that there will be somebody who is competent to attend to cases that go there. And for that matter, if a patient gets there, and even if he does not see a doctor, the facility or the management of the facility still owes that patient a duty. But if you look at the circumstances of the Barnett case, maybe it is pertinent to note that the casualty department was open at the material time. And probably if it had not been open and it was closed, the argument might be that no duty of care would have arisen, as it were. And that was why Justice Neild made the point in the Barnett case that, quote, there was here such a close and direct relationship between the hospital and the watchmen that there was imposed upon the hospital a duty of care which they owed to the watchmen. So maybe let's look at it this way. You rush a patient to a hospital, maybe in the night, something has arisen, emergency, you rush the patient there. And you get there, there's no nurse available, no doctor, and maybe just the cleaner. Meanwhile, there is no sign outside the hospital to indicate boldly that this facility has been closed down or the facility is not operational. And you take the patient there, and the condition is such that if you do not get immediate intervention, something is going to go amiss. Will the hospital owe a duty of care towards the patient in such circumstances? What are your thoughts? Anne Abasiafa. Anne Abasiafa.
Hello, sir.
Yes.
Sir, I think there's a duty for the hospital to treat the patient. So far as there is no indication there that they are not working, then opening the facility will mean that they are calling in customers or they are calling in patients.
Okay.
So patients need to receive the unless they put a signpost there that they are not working
Maybe, all right. Thank you, Anne. So let me
down the
vary.
place.
Yeah, thank you, Anne. So let me vary the facts of the hypothetical scenario slightly. And I would like the following people to pay attention because you are going to speak to it. So, who is Arabi? Arabi, is that the? I know somebody called Kofi B. I think Kofi B was a musician who passed on, but who is Arabi? And then KB. So we have KB and then Arabi. So you will be speaking to what I'm going to say. Arabi, then KB. Okay, so let's vary the scenario a little bit this way and say that should we say that anytime you have a hospital which creates impression to the public that it's a 24-hour facility, should a patient go there at any time and the patient does not get a healthcare professional to attend to him or her, and he or she develops serious complications or even die, will the health facility be liable for breach of duty? Or you don't think that it will be reasonable in the circumstances I have narrated to recognize existence of duty of care by the healthcare facility against the patient? Yeah, so area B, and then after that, KB. Okay, if they are not talking, any other person?
All right, Doc. So this is KB.
All right.
Yeah, I am of the view that to the extent that you've put the information out there that you are running 24-hour, system, there should always be a doctor or a trained person at the facility. And so presumably, if you are running a 24-hour shift, there should be a shift system such that some doctors will come in the morning, afternoon, or evening. So at any material moment, there should be a trained person at the facility. And so if someone comes to the facility and doesn't get the necessary treatment or doesn't meet a qualified person for treatment, for me, they've breached duty of care to that patient.
No, but okay, maybe as a follow-up, KB. So is it your argument that insofar as the facility is holding itself out as being a 24-hour service health facility, anytime a patient enters the premises, the facility owes a duty of care to provide a healthcare professional to attend to that patient?
Most definitely.
So in that case,
most definitely.
Related question is that the doctor-patient relationship, does it start when you just enter the hospital? The mere fact that you'll be granted, admission, not admission as you having been admitted in the sense that we understand, like you having been permitted to enter the clinic. Does that automatically trigger commencement of the relationship, or when the patient has actually gone through laid down procedures for attending to patients. Maybe your information is taken, a card is open, and then you are taken through the various diagnostic procedures, and then consultation room with the doctor and all that. What do you think? Not only KB, anybody at all. And I would like you to think closely about this particular aspect. Yes, I've seen Martin. Martin. So Martin, let me use this opportunity to congratulate you, at least in the medical law class. When I meet in the community law class, I'll congratulate you again for not only for winning your election, but you and Nana, what is it? Your colleague, for accepting to represent the faculty in the just ended All African Human Rights competition. So that was a very impressive performance. So well done. So you can now make your contribution. Martin, go ahead. Martin, Wana, we can hear. Yeah, go ahead. It appears Martin is not talking, so let's move on. I'm talking, yeah.
Hello.
Yes, Martin, go ahead.
Okay, sir. So I was saying that in relation to the doctor-patient relationship, the duty of care arises where one has become a patient. So merely entering the hospital does not automatically make one a patient. You become a patient when you have been assigned to a particular medical professional for the purpose of the treatment. However, it will also be for the purpose of public policy and the fact that for the purpose of public policy, if you hold yourself out as providing services 24/7 or 24 hours throughout the week, and then it appears that a patient arises and you do not have the requisite professionals to treat that patient, it will be unfair on the part of the hospital not to be held liable. So in the circumstances of this case, the principle, the duty of care may arise where it is just fair and reasonable to impose such a duty of care in the circumstance, especially in professional cases. So, and it's the discretion of the judge. So in that circumstances, the judge may say that having regards to the fact that they've held themselves out as providing services 24 hours a day, then they should have at least taken steps, pragmatic steps, to provide a shift system where at every point in time there are medical professionals for the purpose of treating the patients. In that regard, it may be fair and just to impose a duty of care. Thank you.
Okay, all right, thank you. All right, so in trying to find out whether a duty of care exists in a novel situation, that is, in a new situation in which maybe traditionally the courts have not propounded that a duty of care exists. We remember very well the test which was propounded by the House of Laws as far back as 1990 in Caparo Industries against Dickman. And there, you remember that the court made the point that 3 elements are essential to establish whether the defendant will owe a duty of care in the circumstances. So 1 was a damage caused to the claimant or plaintiff by the defendant reasonably foreseeable. So what they call like the foreseeability test. And 2, was the relationship between the defendant and the plaintiff or claimant reasonably proximate? And 3, is it just and reasonable to impose a duty of care on the defendant? So that introduces some policy arguments and floodgate arguments and so on and so forth. And for that matter, I will be very happy. It's unfortunate that in our part of the world, we are not getting medical law cases being taken up in the courts every now and again for us to test some of these aspects of the legal propositions we're encountering in the context of rare facts, as it were. Because I will be happy to see people taking up cases. We took our patient to the hospital. We were made to sit at the waiting lounge for 2-3 hours. And no, we were not given a doctor or any physician assistant to attend to us. And then the person's condition escalated or the person died. I would like to see some of these cases being taken up so that the courts will actually have to work out whether it is just a reasonable to impose a duty of care on the healthcare facility in circumstances like that. Of course, if the damage is not reasonably foreseeable, there is no duty of care between the parties. And that was why in the case of Kent against Griffiths, the court established that the ambulance services owes a duty of care to the caller of the emergency number 999. So if due to carelessness, they fail to reach the caller within a reasonable amount of time, and further loss is suffered as a result, the ambulance service will be liable in negligence. So in Ghana, for example, the last few years, we have witnessed significant deployment of ambulance services. And every now and again, we keep hearing the ambulance. I'm not talking about the ambulance of the hearse, that is carrying the cadaver or the corpse, but I'm talking about the ambulance, the rare ambulance carrying patients who are still alive. There are a lot of them around, so we will be very excited to see people taking up cases that, well, I called the Ghana Ambulance Service and my call was answered, but they didn't come, and they said they were coming, they didn't come eventually, and then this thing happened, and for that matter, I am suing them and so on. We'd like to see cases like that coming up. Yeah, so, but important to note that there's definitely a distinction between the health ambulance service and then the fire service. As we saw in the Capital and Counties case above. In Kent and Griffiths, as we have just noted, the court held that a duty of care was owed because they had accepted the call to the individual patient whose call they were responding to. But if you look at the Capital and Counties against Hans City Council we noted above, they were responding to the public's needs at large. So if maybe there's the fire, then the radio station, they're announcing that there is fire at Asafo Market, and the fire service will hear it, and let's say that they are doing their best to get there, and they don't even get there in time, and the fire escalated, maybe people died or things got bent. And then where you have called the ambulance, and then the particular number is used to call them, and they have answered that they are coming. These are two different scenarios. They are not the same. So we have to pay attention to that. Or even like the ambulance service, if maybe on the radio, they hear that, oh, there is an accident or somebody has collapsed at Kumasi Sports Stadium. So if the ambulance service can get there, and if they, for example, decide to go there, but maybe they're not able to get there in time and so on, you don't say that they owe a duty of care in that particular case, because they will definitely be treated as responding to the public's need at large, as it were. But ultimately, what suffices for us to note as whether the court will come to the conclusion that a proximate relationship existed between the defendant and the plaintiff will turn on the facts of the particular case. And for that matter, the more the relationship between the parties, the more likely it is that a duty of care will be inferred. And we know very well the interesting case of Take and Morris. Even in my law of contract class, those of you have taught contract before, when I'm discussing terms, I like citing Take and Morris, a very old case, not because it's about vasectomy, of course, that is also interesting. So in Take and Morris, the defendant, a doctor, a private doctor, that's a doctor who is running a private practice, had been consulted for vasectomy procedure to be done on a patient, but the doctor failed to warn the patient or his wife that there's a possibility of the vasectomy spontaneously reversing. And after a while, the wife became pregnant again, when the couple had expected that they could continue to have unprotected sexual intercourse and there will be no pregnancy, but there was. And despite the fact that the wife was not the patient of the doctor, because the patient was the husband, the court held that she was owed a duty of care. And eventually, when the matter traveled to the English Court of Appeal, it was held that a duty of care existed between the parties because it was reasonably foreseeable that the wife could become pregnant if the vasectomy failed to be effective. So the court was prepared to recognize proximate relationship, if you like, between the wife of a person who had contracted for vasectomy services and its failing. So that was the point that the court made. And similar thing happened in the case of Goodwill against British Pregnancy Advisory Services. But there, the court did not recognize existence of a duty of care. And what happened? There too, vasectomy was performed by the defendant. That is the British Pregnancy Advisory Service. And the patient was advised that the operation was successful and it was not necessary to use contraception when having sexual intercourse. Now, 3 years after the operation, he had had sexual intercourse with the plaintiff, who became pregnant. Now, she alleged the defendant was negligent in failing to advise her partner of the risk that the vasectomy might reverse itself. So the question was, Was there a sufficiently proximate relationship between the plaintiff and the defendant to establish a duty of care? Well, the court answered the question in the negative, that the defendant did not owe the plaintiff a duty of care because the plaintiff was not in a relationship with the patient at the time of the operation. So look at it, the court was paying attention to absence of, if you like the relationship, that there was no relationship at stake at the time that the operation was made. And the British Pregnancy Advisory Service rather owed a duty of care to the patient who underwent the operation and any partner he was with at the time of the operation. So if at the time that the person underwent the vasectomy operation, he was not with you, then later on you came on board and pregnancy occurred, a duty of care will not be owed to you because at the time that the vasectomy was done, you were not the partner, you were not the sexual partner at the time, as it were. Yeah, I mean, there are a number of case law just to help us to illustrate the existence of duty of care, and even in a novel situation. Now, so having seen how the court will determine if a duty of care existed with respect to the claim which a patient is making against either a healthcare professional or the health facility. We have seen how the courts actually go about that. So we would like to proceed to look at the very important element, breach of duty of care. How will the court come to determination that the patient who has succeeded in showing that a breach, who has succeeded in showing that a duty of care existed, suffered breach of duty of care, or the defendant breached the duty of care imposed upon him or the facility, as it were. Well, the burden of proof, the onus, lies on the plaintiff, because you know the maxim that e incubit oratio probatio orito. He who asserts must what? Must prove. So if you are asserting something, then you bear the burden of proof. So if you are certain that the duty of care was breached, you will have to bring the evidence to establish that. Now, to establish duty of care, as you know already from your general law of thought, you must first of all determine the appropriate standard of care, which was required of the defendant, the doctor, or the health facility or healthcare professional in the circumstances which you are complaining that he breached the duty of care. So what was the standard of care? What was the expected manner of conduct or behavior? And as we know that as far as the standard of care is concerned, the courts are not prepared to make allowance for a person who is less experienced than another. So no allowance is made for what? Inexperience. And you know the old case of a nettleship against a Western, which illustrates that a learner driver is deemed to have the same skills as an experienced driver, and that no recognition could be made of the fact that she was a learner driver. So maybe if you come to a doctor who is doing housemanship, if you are not working under supervision of a medical officer or already qualified doctor, and you take up a case and something goes wrong, it will not be a defense to you that you were just a housemanship or a houseman. Yeah, so that is the wisdom from Nettleship against Weston. And as also happened in the case of Wilshire against SS, Area Health Authority, the English Court of Appeal had to consider the liability of junior staff in hospital. And as you know, the case was about a premature baby, where if he had been treated correctly, his life would have been saved and he would not have died. He required extra oxygen in order to survive. But on 2 occasions, he was given excessive amounts of oxygen. And yes, I mean, in terms of causation, a lot of things that we can say, but for our present purpose, we are not talking about the causation. We come back to that later on. The courts had to consider the defendant's argument that the staff who attended to the patient were inexperienced and did the best they could in the circumstances. But as we have stated already, when it comes to standard of care, no allowance is made for what? Inexperience. And for that matter, inexperience was no defense, even though the court recognized that there could be learning on the job. And an inexperienced doctor always had a more experienced doctor to call on for help and guidance. And so the same thing applies to a doctor who is doing housemanship and the supervising doctor. And again, in terms of the standard of care, it is context specific. Context specific in the sense that where we are complaining that you breach a duty of care you owe a patient, in making the determination, we have to first establish what the standard of care was at the time that you are alleged to have breached your duty of care. So the time we are interested in the time that the negligence took place, not the time that we are doing the trial. Let's say that the patient might have suffered the alleged negligence 3 years ago, and it's now that the trial protocols and everything have been completed for actual trial to be done. And the court will not have to use the standard of care now to judge the negligence which happened 3 years ago. And that was why Lord Denning, in his very usual interesting style of articulating his view, in the case of Roe against Minister of Health, noted that one cannot look at 1947 accident with 1954 spectacles. I mean, that simple expression is quite illustrative of the point we are making, that when negligence has occurred and we need to work out the standard of care, which was required of the defendant, doctor or healthcare professional, we will use the standard of care at the time, or in force at the time the negligence was alleged to have occurred, and not when we are doing the trial or the adjudication. Hence, Lord Denning's statement, we cannot look at 1947 accident with what? 1954 spectacles. Maybe I would like you to read the case of the L against the West Midlands Staffordshire Health Authority. So having noted that the standard of care will be determined at the time the negligence occurred, it is important for us to remember that as far as medical negligence is concerned, for a very long time, despite the fact that we saw the case of Montgomery against Lagnacher being decided in 2015, and then the UK Supreme Court suggesting that, well, Bolam test is not, if you like, the answer to every conceivable question as far as doctor-patient relationship is concerned. And then when it comes to the obligation of the doctor to make disclosure of information before a patient can make up his or her mind and give proper informed consent, is not a matter of just the Bolam test, but we will also look at other things. It is still necessary for us to remember that when it comes to medical negligence, especially as not a failure to make a disclosure of information, but maybe as a particular positive act, something which was done or failed to be done in the other treatment or the diagnosis, probably, as opposed to mere disclosure, because as far as mere disclosure is concerned, we say that Bolam is no longer the test, but Montgomery against Lagnacher. But of course, that is the decision in the UK. As far as Ghana is concerned, at least according to the Asante Kramo case against Attorney General, and then the Jan against the Goldfields and all those cases, they still follow Bolam. And the Montgomery against Lagnacher, as far as my research and awareness of the state of the law in this area is concerned, has not been applied by any reported decision in Ghana. And for that matter, we are still saddled with the Bolam against Ferren Hospital Management Committee test, which was decided in 1957. And the Bolam test is simply that the standard of care which we need to use in gauging whether there's been a breach of duty of care by the defendant in medical negligence is simply that of reasonable medical practitioner. And for that matter, it is necessary for the plaintiff to establish that the doctor in question or the healthcare professional in question did not act as a reasonable doctor would have done. If you're able to demonstrate that what the doctor did falls short of what a reasonable doctor would have done, then you have succeeded in proving breach of duty of care. On the other hand, if different doctors may have differ as to how best to treat a patient in the circumstances in which you are complaining about negligence, then the court will say that the particular defendant cannot be held liable for clinical negligence. Maybe just to quote the words of Justice McNair, in which, who initially propounded the famous or the so-called Bolam test. This is how he put it, and I quote, "The test is a standard of the ordinary skilled man exercising and professing to have that special skill. A man need not possess the highest skill at the risk of being found negligent. It is well established law that it is sufficient if he exercises the ordinary skill of an ordinary competent man exercising that particular act," unquote. So that reinforces the so-called the standard of the reasonable medical practitioner. And In the Bolam case, so the point was made further that just because there's a body of opinion that we have done things differently does not mean that the defendant is negligent, providing that the defendant acted in accordance with the body of opinion that will have carried out that act that way. In other words, if, for example, in treating the particular patient, you gave certain prescription or you did certain procedure and the patient has suffered certain injuries or certain unfortunate outcome or death or whatever. And later on, there's a case about medical negligence. What Bolam is telling us is that if there are other doctors who will say that they will not have made the prescription this particular doctor made, or do not have embarked upon the procedure which this particular doctor embarked upon, that per se is not conclusive of the matter that the doctor who is a defendant in the present case is liable or guilty of negligence. No. If the defendant in question, for example, acted or what he did, some other doctors who have also approached the problem in the same way that he did, then despite the fact that some other doctors would not have done it the way that he did it, he will not be liable or guilty of negligence. So that is the wisdom of the so-called Bolam test. And for that matter, what that will mean is that as far as Bolam test is concerned, it is like the doctor who virtually decide the standard of care. Because all that it means is that if I am sued, I need to be able to line up a number of doctors who will come and take oath and say that yes, in their medical practice, when they get cases as I got, they go about it in the same way that I did it. If that is so, I could get off the hook. Yeah, so that is the point to note. And just to let you know how Bolam actually seems to suggest that it is rather doctors who determine the standard of care rather than maybe the courts, as done in number of other cases. You may want to contrast Bolam with the Edward Wong Finance Company, which you have in your material. Again, let us note that we have a plethora or long line of cases in which Bolam test has been approached. And White House against Jordan, which is a House of Laws decision, provides a good example of application of a Bolam test by the highest court of UK. Because Bolam was decided by just the High Court in 1957. And if you look at the application of the Bolam test, it appears to allow judgment by professional colleagues to substitute for or displace judgment by the court. And that is why some scholars or commentators would even accuse the courts for having abdicated their primary duty of making a decision as to whether a doctor has actually breached a duty of care or not, as happens in other negligence cases. And that, and of course, shockingly, if you look at the House of Lords decision in the Maynard against West Midlands, they made the point that it was not the way ahead for the court to choose between two differing opinions. And it did not mean that one was right and one was wrong, just because they were carried out differently. In other words, it didn't matter. The mere fact that what we are complaining about, we have, let's say, two schools of thought. One group of doctors saying that you have done it the same way that the defendant did. Another group of doctors saying that they wouldn't have done what the defendant doctor did. Doesn't mean that maybe those who are saying they will have done it the same way the defendant doctor did are wrong, or those who said they will not have done it the same way that the defendant doctor did are right. It doesn't really mean that. And of course, that is problematic because some commentators are of the view that the courts seem to be unreasonably differential or showing too much respect to the medical profession rather than subjecting them to rigors of proper accountability, as it were. Yeah, we have already seen the case of Sidawe as far as Ebola was applied in the context of disclosure of information. But you know that because of the Montgomery against Nkrumah decision in 2015, Sidawe is no longer a good law. It's no longer a good law because Sidawe said that maybe Bolam should be followed, except that some of the judges suggested that where the particular approach with the doctors were suggesting appeared to be not really sensible. Some judges expressed the view that there could be a departure for the Bolam, but that was not the ratio decidendi of Sidawe. But thankfully, Montgomery against Nkrumah has actually come to jettison all of that. And for that matter, it doesn't even make Bolaito against Hackney Health Authority very important now. You have to remember Bolaito case. The court sought to qualify the unreflective application of the Boram test, and Lord Brown Wilkinson, speaking for the House of Lords, who, for example, suggests that the mere fact that a body of opinion or body of doctors are saying that they have done what the defendant doctor did should not be taken at its face value. The court should subject it to straight logical analysis. If the court was the view that the opinion by the doctors who are saying they have done what the defendant did, for example, cannot withstand a proper logical analysis, then the court is not bound to follow what those doctors are saying. Yeah, so that was, if you like, a bit of modification of Bolaito. But again, Bolaito is in relation to disclosure of information to a patient before the patient will make up his or her mind to accept a particular proposed procedure or not. And for that matter, in the light of the recent decision of the UK Supreme Court in Montgomery and Nkrumah, as I've mentioned in 2015, we still say that Bolaito has been overtaken by event, and we just need to be aware of it for academic purpose, but not as really being the prevailing position of the law, as it were. Okay, so we will now turn to causation and defenses. So now we maybe we give you a bit of a breather. Yeah, any questions so far, please? Okay, in absence of question, let's move on to, I notice we have about 90 minutes before you go on for your another class. Martin, you have land law, not so? After this? Part-time students, you have a land law after this, or? Era?
Yes, sir, please.
So, Rabi, you say I've succeeded in getting you to talk. Initially, I wanted you to talk, you didn't talk, you see? Okay. Okay, so having established the existence of the duty of care, then the breach of duty of care, and you've stated that in establishing like the breach, we need the standard of care. And actually the test, as far as the standard is concerned, has been like the Bolam test. The only exception or qualification mean that with respect to disclosure of information now, because of the Montgomery case, Bolam is not applicable there, but outside disclosure type of cases in medical negligence, Bolam is still a very important decision. And I even added that, as far as Ghana is concerned, even for both disclosure and non-disclosure forms of medical negligence, I think the prevailing test is Bolam until the court has been courageous to say that Bolam is no longer a good law, so they're making a departure from it. So that is one thing that we should keep in mind as far as the law is concerned. Hello, I'm teaching on Zoom. Yeah, I'm teaching. All right, right. I'm teaching. Yeah, so that is what we should keep in mind. So we now come to causation. It is not enough for you to say that the defendant, be the healthcare professional, the hospital, vicariously, owed you a duty of care. Neither is it enough for you to succeed in saying that that duty of care was breached. But more importantly, you should be able to satisfy the third conjunctive requirement. And the requirements are not disjunctive, they are conjunctive, meaning that all must be established positively. So you must be able to establish that the injury that you are complaining of actually emanated from the breach of the duty of care. And that is why causation becomes very important. And we know from law of tort already that the Bradford test is used in general tort in trying to establish whether the breach caused the injury which the defendant is complaining about. So you ask yourself, but for the defendant's negligence, would the claimant, that is the patient, have suffered those injuries? In other words, can we say that had it not been for the negligence of the doctor, would the patient still have suffered those injuries? Well, as far as clinical or medical negligence is concerned, we have certain difficulties because the patient or the plaintiff needs to be able to distinguish between, one, the effects of the alleged negligence, and two, the patient's pre-existing conditions. So that makes it more complicated because the patient may have some pre-existing condition. And so that one is different from what the actual alleged negligence caused. So how far can the injuries which the patient is complaining about emanate from the pre-existing condition and not just from the breach of duty of care by the doctor or the healthcare professional? Now, as you remember from the case of Barnett against Chelsea and Kensington, the defendant had made argument that it was the plaintiff's condition itself which caused the injuries and not the defendant's alleged negligence. And as you remember from that case, the Barnett case, there were 3 night watchmen. They drank tea and attended the casualty department and made a complaint of severe vomiting. So the tea was said to contain arsenic, a very highly poisonous chemical. The nurse asked the doctor to attend, but he failed to do so. And later on, one of them died. And the defendants, yes, breached their duty of care. There's no doubt about that. But question is, could their breach of duty of care actually be blamed for the death and for the worsening condition? Because even if the patient had been treated promptly, if there had not been a delay in treating the patient, arsenic, arsenic is a very serious poison that no treatment would have saved his life, except maybe a supernatural intervention, as in a miracle. So you notice that in some cases, you'll be able to prove that the defendant actually breached the duty of care, but you may not succeed in establishing that the breach of that duty of care actually caused the injury, which you are complaining about. So you can contrast that, or you can see a similar application of that case and the later case of a hot against edge. Hot against edge. And here, the plaintiff or claimant fell while in the shower. And I would like to advise you to be careful when you get up from bed. Because when you get up from bed, you can get a sudden heart attack or some, because people are not aware. The same way to when you're in a shower, you can easily slip and get injured. So just be careful. So in halt and edge, the plaintiff fell while in shower, and then he called his GP. His GP, that is a general practitioner, his doctor. Now, she did not see her own doctor, the doctor that she usually sees at the hospital that she's supposed to be attending, until the following day. 2 days later, she went to the hospital where subarachnoid hemorrhage was diagnosed, and she suffered a stroke and sued in negligence. The doctor admitted negligence. Duty of care had been breached as she had not seen her GP sooner, but causation was not satisfied because if the doctor had seen her at an earlier stage, she had not presented with any history of symptoms to lead the doctor to send her to hospital at an earlier stage. In other words, if you go to your local doctor, there are certain cases which require advanced treatment, and referral will have to be made to, let's say, a referral hospital, maybe a district hospital or to tertiary hospital like Omfanochi or Kolebu Teaching Hospital. But if from the records known to the doctor that will be attending, there's no previous symptom that, let's say that you were at a high risk of stroke and so on, the doctor, even if he had, attended to you at the reasonable early stage, is not likely that any referral will have made, and for that matter, the stroke will have ensued anyway. So that was the difficulty in Holt and Edge in trying to establish the causal link or the nexus between the breach of duty of care and the complaint injury, the negligence, and the stroke, which happened. We also have this related difficulty of multiple causes of the patient's or the plaintiff's injuries, where the injuries are complaining of might have been caused by more than one thing. How do we blame it on the defendants? And you know from the case of Wilshire against SS, Area Health Authority, from your law of tort model, where a premature baby suffered from a number of disabling conditions. The plaintiff claimed the blindness from which the baby suffered was caused by an excess of oxygen. There were, however, a number of different possible causes. So during the trial, medical evidence which was adduced was inconclusive as to whether the excess of oxygen caused or materially, that is substantially, contributed to his condition. The court below held that the defendant had caused the injury, despite the fact that it was impossible to clearly pinpoint the precise contribution the negligence made to the baby's condition. But eventually, when it came on appeal in the highest court of the land, in the House of Laws, the Area Health Authority's appeal was allowed. And the courts applied the principle in McGee against National Coal Board. And I hope you remember McGee against National Coal Board. Will anybody remind us what happened in that case if you haven't forgotten your law of thoughts? Any volunteer? Before I mention names, can I call? Okay, let me release all of you so that if you want to speak, you can just talk. So now you can unmute yourself if you want to speak. I don't need to call you. Any volunteer? Any volunteer? Not making the class interesting at all. It's 5 minutes to 7. I will end the class here on the note that you go and read again McGee against National Coal Board, and of course, all the other cases that I have cited. So we continue at our next class. And those who did not have the opportunity to present, I haven't forgotten, I'll work with our class leaders, Elsie and Martin, so that we find one day in the week and have a virtual presentation session for those who have not presented to do your presentation. So until then, have a very good night.